SwayamPrabha. Digital India. Educated India.
Good morning viewers, this is Dr. Ashwini Siwal. I am from Faculty of Law, University of Delhi. I am here to discuss an interesting topic in this series called Law, Science and Technology. Today's topic is lecture number 2 of this series. This topic is basically on the nature, scope and interface of law, science and technology. The earlier lecture was pertaining to the philosophy and the policy of law, science and technology. This lecture is basically on the nature, scope and interface of law, science and technology. Well, dear viewers, before I begin talking about this lecture, or I start discussing this, let me tell you that this series called Law, Science and Technology has various lectures and various interesting lectures on the interface of law, science and technology, and we have tried to include every aspect of or every possible aspect of the legal field which has some bearing with the technological developments or some scientific developments. We have also tried to bring in in the syllabi or in the format of this course all the emerging technologies and the laws pertaining to those emerging technologies, like AI and law. Then we have a lecture in this series on drones and law, on robotics. So we haven't skipped anything which is possible to be included in this particular lecture series. My dear viewers, I urge you to systematically see this lecture series, because it begins initially with the theoretical underpinnings on law, science and technology, but the later lectures in this series shall be more interesting because they are specific to particular disciplines or particular fields of law, like AI and like intellectual property, like robotics, etc. So this lecture predominantly is theoretical and maybe a bit monotonous vis-a-vis to other lectures in this series, but that does not mean that this lecture series is not interesting. It is really very interesting, but we have to learn the theoretical underpinnings of law, science and technology, their interface, the scope and nature of the interface. Well, so far as the nature of this interface is concerned, or this field is concerned, let me tell you that it interfaces or intersects on many occasions with the legal discipline, and the legal discipline on the other hand interacts with the or intersects with the law and technology on many occasions on the other hand, right. Both have some crucial role to play in each field, or in respect to or against the particular against the different field. Both are important, both are equally challenging, both are equally complex issues. The scientific community is seen these days using or discussing or talking about the legal issues or the legal frameworks. On the contrary, the legal fraternity is seen these days discussing the scientific developments and use or probable use of those scientific developments into their field. So this is very fascinating that both the communities are discussing the different disciplines or their usages into their respective domains, and to a great extent the two domains merge. Let me give you an instance that law is ordinarily known as what? As a discipline which governs, which regulates the society or its normal day-to-day affairs. On the other hand, technology is known as a field which relies or which basically focuses on the progress, not on the process, and moreover it basically focuses on developing new products or processes or new tools which can make the life more easier, and which can address the long felt needs, or which may provide solutions to the long felt need of the civil society. But if you look carefully, at times the technologies are acting as law and laws are acting as technology. The best instance to understand is the technological tools like surveillance cameras, or the best example is the CCTV cameras installed on roads, in organizations and everywhere. So at times we get regulated because of those technological tools installed there. They are technological tools primarily. They are not any legislation or a piece of law which will govern us, which will regulate us, but yet they are regulating us, and we get definitely scared, as if a policeman is standing next to us. If there is a camera installed somewhere, and if we think of doing something wrong, we really stop there, because that camera is acting as a law in this case. And vice versa is also true, where at times the law acts like a technology. We have many manifestations or many laws which are so technologically laden, or so technologically jargon based, technological jargon based, like intellectual property law, cyber law, and then we have Digital Data Protection Act, and so on and so forth. There you feel as if you are not a law scholar or a law student, rather you are a student of a technology, right? The fields like intellectual property, the fields like information technology, they have a bearing on all the scientific feats and endeavors, be it biotechno, be it nanotech, or be it drones, be it anything, because ultimately the intellectual property is conferred. So this role change, or the change in the roles of both fields, is somewhat very fascinating to a scholar, or to a law scholar like me. And I believe that the day is not far away when both will merge and both will replace each other, or at least act as a replacement on many occasions to each other. Now with this background, or with this brief note about the law, science and technology and their interface and scope and nature, let me come to some of the slides where I will try to portray the relationship of law, science and technology. This relationship is asymptomatic. The technology has had a vast impact on mankind and on society as a whole. Ever since mankind emerged from Stone Age to Industrial Age and finally to this technological age, there has been no looking back, and technology since then has grown in abundance. Well, this is something known to everyone, that we have come far away from those times when there was a Stone Age, and there has been an exponential and a meteoric change in the way of living, in the way of communicating, in the way of thinking, in the way of in the field of law, in the way of arguing the cases in the courts of law and preparing the briefs in the courts of law. So at this point we need a medium to regenerate moral and immoral conduct in the society, and this is where the law comes as a savior for us. And in this technological age, where the challenges are myriad and many and unknown, we need a tool in the form of a law which acts as a savior to regenerate moral and immoral conduct in the society, which is a technological society, which is heavily influenced by the technologies. Law is important because it governs what is acceptable and what is not. It is an effective medium which can bring about any social change. The role of technological advancements in shaping a society is in no way less than the laws. Well, both has been given equal importance and are really equally important. The technology in the development of the society is paramount, so is the law. And if there is no regulations, no norms, no order, then I believe there shall be no technological developments. So, law also plays a paramount and equally important role in the society. So, they are at par with each other in their sweep or in their respective domains. They act as most important tools for the betterment of the society, for the welfare of the society. So, these advancements bring along significant opportunities and some challenges. But in the both fields, there lies many challenges, and there lies a lot of opportunities. We have to discuss those opportunities as well as those challenges which lie ahead in the fields. Well, we are on the verge of social revolution, where there is a need to define socially and digitally acceptable behaviors. We need to ponder upon new social realities created by technology and what it means for individuals and society. We also need to take the technological domain under the ambit of law to protect itself from its effects on us. The law needs to catch up with the rapid technological advancements. It has to come up with necessary legislation, regulation, monitoring, surveillance, and ultimately to let the technological sphere grow exponentially. If one fails or one restricts the way it, or in the way in the efficacious way it works, then the other will not progress. This is the worry, that both are different fields, but both are at par into their respective domains. Both are equally important and paramount. But if one fails or one does not efficaciously function, then the other is likely to simultaneously or as a corollary stop to function in the times to come. The reason being, we can understand it by an example, that when the laws are made to regulate the scientific feats, then we see the efficacious and the potential benefits for the society and for the well-being of the mankind. But when the laws are not there in place appropriately, then we see that the concerned technologies don't dispense in the way they are expected to dispense, and they don't actually really work for the welfare of the mankind. So, it is also true vice versa, where the technological feats, if they don't efficaciously work, then law fails, or the legal order also fails. So, we have a relationship which is such a relationship which largely is mutual, and there are effects of both on each other. There is an effect of science and technology and law, there is an effect of law on science and technology. When it comes to effect of science and tech on law, then we see that exploring this relationship between law, tech and regulatory governance has always been a challenging task for policy makers. Technologies are often seen as ordinary objects of formal law that can fit into traditional doctrinal classification, but if technology is questioned and challenged the traditional boundaries of legal thought, well, in the case of law, there are no doctrinal structures and no doctrinal questions, but in the field of technologies there are structures in which they perform, and ordinarily the technologies are considered as what? Objects of formal law that can fit into traditional doctrinal classification. Some scholars even argue that technology is law, right, and given that the employment of technology for control purposes in regulation provides opportunities to directly or indirectly shape human behavior in legal terms. I was giving you an example of technology acting as a law at the outset, or in the beginning of this lecture, where I was telling you that at times law is replaced by a technology, like installation of a camera which acts as a analogy may be drawn, who acts as a policeman, or it acts as a policeman, or a watchman. So, scholars have argued that technology is law because technologies these days are employed for control purposes, for regulatory purposes, and they indirectly or directly shape the human behavior, right, in the common parlance. And it is seen that wherever you see such technological measures taken, we don't dare to cross our limits. So let us see it with another example. We all know that piracy is a big problem in the film industry, and copyrighted works are susceptible to piracy or copyright infringement. But technological measures like right management or circumvention, or some other technological measures are opted or are used by the right holders to preclude the infringement. And when we dare to circumvent those technological measures, or when we dare to circumvent or tinker with those technological measures, we are either notified or alerted by the technology in question, or we are at times also by the technology itself told that if you will do this, then this kind of a consequences may incur, or may occur or ensue. So this kind of a technology which is acting as a law is a really fascinating field, or is a really fascinating development. And a lot of such right management tools or digital management tools, DMRs, are used for preventing intellectual property infringement, etc. However, it is difficult to determine whether it is technology that challenges the law, or the law that shapes or even predefines the development of paths of new and emerging technologies. Well, so far as this is concerned, then I would like to take you to the previous lecture of mine, which is about the philosophy and policy on the law and technology, and I would like to draw your attention specifically to those portions of that lecture where we see which one predefines the other, and which one is basically challenging the other. Though it is very difficult, but we see that there are both I mean there are challenges from both the sides. There are challenges and issues from both the sides, be it law or be it the science and tech. So to certain extent you may say that both play a crucial role in shaping each other. The law plays a crucial role in shaping the technological feats and developments. The technology plays an important role in shaping the laws. And the best instance to understand is that whenever there comes a technology, the law is made to address the issues. And it is also argued that the ex post approach or ex post approach is not very good, but ex ante approach is also not very good, because if we merely or solely go by ex ante approach in making the legislations and keep the legislations ready for future technologies, especially when we do not know about the potential of the future technologies and their their behavior, etc., and the way in which they will function tomorrow. We can't have those laws in a comprehensive sense, or we can't have such laws to be called as adequate and efficacious laws. So both the approaches are there, where the laws are reactive in nature, and at times they are proactive, and they are made prior to the existence of, or prior to the making of a new law. So which one shapes another is a question which we can reconcile by saying that both the technology, both the fields can shape each other, or are shaping each other in a way which strives for the betterment of the society and for the betterment of the mankind. So technology and regulation are often portrayed as adversaries, but this is not true. They are really not adversaries, rather they are complementary to each other, and they supplement each other or their role into the society. In a traditional legal setting, their relationship is limited to the grounding of legal reasoning in expert knowledge and scientific evidence. Well, that is true to a great extent, that in traditional legal setting their relationship is limited for evidencing, for expert evidencing, etc. But in the non-traditional legal setting, we see that their role is not limited to the merely to the expert evidencing or expert opinions, etc. It goes beyond these traditionalist ways of using the technologies. If we look at the use of AI tools these days in the legal field, we find that legal tools are used to the extent of extracting the data from the voluminous documents, or analyzing those documents, or for identifying the cross referencing, or for drafting the contracts, or for drafting the pleadings, etc. So, in the traditional legal setting, it is true that the evidencing is or expert opinion are the few instances or few manifestations of the intersection of law and technology, but in the modern day legal setting it is not true. However, as law becomes more and more involved in regulating technological processes and products, it may inhibit or stimulate technological change as such. That is also true that the laws made by the legislature should not be such which inhibit the technological sphere. Otherwise, it will stifle the innovations, it will stifle the technological pace, or it will stifle the technologies to have a conducive environment to prosper, right. So, laws or law making by the legislature should be such which does not inhibit the technology, and the same is true from other way around as well. The technologies should not be such which challenge the law to an extent that they can't be codified or they can't be regulated, because they have the tendency of turning the table, or they have the tendency of, you may say, posing a great risk to the society. The technologies these days have the potential of posing great risks to the society. So, for technologists, it is really necessary to understand that they must not do anything, or they must not create any such technologies which may gonna challenge the lawmakers to an extent where they can't legislate. So, the employment of the technology as a regulatory actor indicates a shift from a traditional legal order to a technologically managed order. As I told you that technology is employed to regulate things, which we called techno regulation. We have known legal regulation or legal regulations prevailing in the past, but now we have techno regulation where technologically managed order is brought into the society, and it replaces the role of the law there, or it just replaces the role of the legal field altogether. But at the end of the day, the court trial and court procedure is required to either convict or acquit the culprit, or to ultimately decide the fate of the convict. But it at least has some role, or you may say it has some role in the regulatory sphere. The advent of some technologies like blockchain and transposition of contractual relationships into smart contract code that simulates the function of legal contracts through technology, or the adjustment of software codes for autonomous vehicles or traffic regulations, may also signal a shift from traditional notion of code is law, that is code having the effect of law, to the new conception of law is code. Well, this is very interesting that some new technologies like blockchain and then smart codes, or adjustments of the software codes for autonomous vehicles to traffic regulations, these are signaling a shift from traditional notion of code is law to law is code, or to the new conception that is law is code. There is a difference when we talk about code is law and law is code, right. There lies a great deal of difference. These two things are totally different, because code of law is code having the effect of law. It may be a techno regulation, it may be a technologically managed order, but on the other hand, a law or a piece of law legislated by the legislature is the code which has to be followed by the public or by the scientific community as well. So, both things are different, but there is a transition where code is law is shifting to law is code, and vice versa, right. According to this narrative, the law is progressively starting to assume the characteristics of code, given the inclination of to replace current laws and regulations with technical regulations which can be enforced ex ante through code. Now, this is something hypothetical, more hypothetical than real, because it is not so easy to have ex ante codes which will define the contours of the future technologies, but law is attempting to or striving to become a code, or you may say to ex ante have such piece of laws or regulations or legal frameworks which will cater to the future technologies. This can be clearly seen in the case of smart cars that could simply refuse to start the engine if the sensors indicated that the driver had not fastened their seat belt properly, or of the programming of no fly zones in drones. So you see this new ex ante rules, where the smart cars or our vehicles these days, they will not start if the sensors are indicating that the driver had not fastened the belt, or the programming in the drones where they will not go to the no fly zones. So such progressively changing sphere, or such progressively changing things are best examples to indicate that law is progressively answering the questions. It is the law which requires a car maker to have this feature where the car will not start, right. So for future ready vehicles, wherein the cars will save people from the accidents, or they will have more and more features which will make driving hassle free, which will make it free from any kind of accidents, etc. The laws are requiring that there has to be sensors, the laws are requiring there has to be minimum number of airbags, the laws are requiring that there has to be no fly zones, etc. So that the clear cut division between law and technology has faded away in modern times, on account of the fact that scientific notions and technological concepts such as gene editing and autonomous machines have penetrated legal categories and triggered the reconsideration of traditional legal terms such as autonomy and privacy. Well, in modern day technological concepts like gene editing and automated vehicles or automated machines, they have triggered the debate of reconsideration of traditional legal terms such as autonomy and privacy. Now with these with these new technological feats or technological developments, where we have advanced to the level of gene editing or autonomous machines, etc. Privacy or contours of privacy, etc. are to be changed or are to be reshaped or redefined, because now your privacy is no more safe, or it is no more intact. It may be always susceptible to transgression or intrusion by anyone. Some scholars have argued that mutual acknowledgement of boundaries between law and technology has been replaced by a co-production regime where technology and policy are interrelated. So we have all kinds of arguments coming. Let us have a look at the recent developments so far as these two fields, which are seemingly different but are same, but are equally important but seemingly different, and not so important, but they are both important, and they have a supplemental role or complementary role. Several events in the past decade have significantly increased the tension at the interface of science and law. First, the science and technical technical evidence is more frequently presented in litigation and has become more complex. Well, electronic evidencing or evidencing by drones, etc. are being adduced in the courts of law. The evidence taken through new age drones or surveillance devices are being adduced in the courts of law. So this technical evidencing or scientific evidences has increased in the courts of law, and it has made it very complex. The number of cases involving scientific and technical information has increased significantly. Such proceedings often attempt to resolve issues that scientists and engineers view as within their domain, and why it is happening. Is based on the fact that these days they scientists and engineers, they don't find law as a very complex, or lawyers on the other hand similarly, they don't find science and technology as very complex. So they are merging, and both fields are significantly leading to new kinds of tensions apart from advantages. So second, the second instance is the health, safety and environmental regulations are more frequently based on epidemiology, ecological modeling and other statistical methodologies, and are intended to address risks that incorporate assumptions that may be difficult to verify. Parties affected by such regulations often challenge the scientific foundations of these rules, opening up for public review the internal process for the underlying science. So these are the recent developments which are challenging or which are posing new kind of tensions between these two fields and between their interface. The legal doctrines which define different norms for new fields which are more like scientific fields in the law, like intellectual property, have increasingly becoming prominent in the past few decades. New industries have a reason to exploit fundamental science, most notably molecular biology. These advances have presented new challenges to the patent system. So in the fields like intellectual property, the legal doctrines which are defining these fields, they are constantly at stress, and new industries have a reason to exploit fundamental science like molecular biology, and these advances are presenting new challenges to the patent system, because the patent law in the country is very old. We have a 1970 Act on the patents. Prior to that, we have had 1911 Act on patents and designs, and at that point in time, these new advances in the science like molecular biology or nanotech or biotech were not available. But now with these new advancements, the legal doctrines needs to be changed or redefined. So finally, in a number of ways, legal decisions are a part of every scientist and engineer's daily existence. Laws and regulations governing intellectual property, access to research data, research misconduct and grants and contracts are few examples where both the communities, the science and scientific community as well as the legal community or the fraternity, they discuss both the disciplines, the science as well as the laws, right. Just as science and engineering are increasingly present in the courtroom, legal decisions are also prevalent on how scientists and engineers conduct their research and conduct their or design their research activities into their laboratories. So law has reached to laboratories and science has reached to the courtrooms. In a nutshell, we can say this, and this dramatic or drastic change or shift is not overnight. It has taken decades to reach to this level where these two seemingly different fields have on the brink of merging or on the border of merging with each other to a great extent, and the time is not far away when the science students will be mandatorily taught some legal underpinnings and vice versa. The law schools have already started specific courses on law, science and technology. The law schools in India, even some IITs in India like IIT Khanpur has opened up a school on intellectual property law dedicated to law right of the intellectual property. So the scientific or you may say the science institutions are going to or should start some informatory or you may say some preliminary introductory kind of discourses at their domestic level of law and vice versa, and that is how this interdisciplinary work will prosper, because both are indispensable for each other, and without their coherence or harmony, the probably the society will not prosper to the extent to which it has prospered or it may prosper. Now, coming to bridging the science law divide, it has already bridged or it has been already covered to a great extent, but yet there lies a scope for bridging it. The pursuit of truth is a goal of both science and law. Science is almost always open ended. It is a process for investigating nature that reaches tentative interpretations based on the data and subject to reinterpretation as continuing investigations generate ever more data that modify prior understanding or provide new insight. So is the law, which requires constant refinement and reinterpretation. So both have both are dynamic in nature, both are lively, both are not static. In science you need redevelopment, redefining, reinterpretations. So in the case of law you require constant refinement and reinterpretation. So for both professions, society often demands that practical decisions be made on the basis of should not be made on the basis of incomplete information, rather on the basis of complete information. So both scientists and judges or the lawyers seek explanations for phenomena to gain a better understanding for a particular situation, right. This may perhaps bridge the gap that the scientists as well as the judges, they seek explanation for a phenomena to gain a better understanding, and they need to refer to the precedents and the patterns. The scientists are also supposed to refer to the precedents and the patterns. The lawyers are also required to refer to the precedents and the patterns. Only then they can go ahead or proceed ahead. The scientists, if you look at the modus operandi of the scientists or in the science, they seek truth through an iterative process wherein a hypothesis is posed, data is collected and analyzed, and new understanding is gained, and then they generate new lines of inquiry. While this may appear to be straightforward, in practice science is often surprisingly messy. The result is, best case scenario is transparent process that provides an opportunity for correction and refinement through peer review and further study. In science, evidence is continuously gathered, challenged, refined until consensus develops through a degree of uncertainty is associated with almost with most science conclusions. The scientific community readily accepts that today's knowledge could be revised if new data and findings lead to new conclusions. So this is the modus operandi of the science, where it necessarily rely or it relies heavily on the data collected, on the analysis done, or on the consensus built by the scientific community. And there lies a correction and refinement or a scope of correction and refinement in the field of science. When it comes to modus operandi of the law, law also builds on the past, though the change proceeds at a more deliberate pace or at a slow pace in the case of a law. In interpreting the law and in some admissibility decisions, precedent is given great weight. In fact, in every court in the country, precedents are given great weight. I mean, precedent means here the previous judgments or the decisions given by the courts of law, and judges typically do not have the option of postponing judgment until additional information emerges. In areas ranging from climate and environment to medical and pharmacology, regulations and laws are written even though scientific understanding may be incomplete and uncertain. Law has to regulate everything, even if they do not have the complete information. They invite the experts to give their opinion and to assist the courts. They are called amicus curiae, wherein the experts are assisting the courts in determining, and the lower the law making process also involves the technical experts or domain experts in law making pertaining to such fields like medical, pharmacology, environment. Legal disputes must be resolved without delay based upon the data at hand, and legal community must respect legal conventions that may constrain the search for truth. While relying on legal precedents established by previous rulings, such precedents may impede consideration of advances in science and technology as they emerge outside the courtroom. Well, the law's modus operandi is basically to rely heavily on the precedents, but at times it is disadvantageous also, because what happens is that legal precedents restricts the courts or the lawmakers and it eventually impede the advances in the science and technology. So, it has to be carefully diluted, or such impediment should be carefully diluted, that the laws should not restrict the development in the science and technology, because development of a scientific temper is one of the constitutional duties under the Constitution of India, and which is rarely talked about, which is rarely followed, or which is rarely discussed, but it is one of the constitutional mandates on the states or on the country, that every state or every institution shall strive to develop the scientific temper. So, Parliament as an institution should not curb the scientific temper by impediments, or by bringing in such impediments which will hamper the science and tech, or the developments in the science and tech. When it comes to legal process and science technology, change has been brought about by technology, and it must be managed in such a way as to minimize the adverse effects prospectively before harm accrues. We all know that a lot of change has been brought up by the technology, but it needs to be managed and minimized. I mean, its adverse effects are to be minimized before the harm accrues. But is it possible that the technological change which has come, and which is in the public sphere, is it possible to restrict it before it results into harm, or if it creates, or it basically harms somebody? Well, this is very tough, but legal process tries to do that by making ex ante provisions or ex ante regulations. Thus, maintenance of social stability against the impact of science technology requires that we identify and promote, along with the primary beneficial consequences, the desirable second order consequences, and reduce a practical minimum those second order consequences that are unintended, unanticipated, and undesirable. Three social institutions presently serve ad hoc roles in technology assessment. One is market, the second is court, and the third is legislatures. So, these three institutions with which we are concerned, specifically the legislature in the law making, and the courts in our today's discussion, when we are talking about the law and AI, when we are talking about the law and science and tech. Market also remains one of the ad hoc regulatory measures, because market at times also stops some such technologies or technological feats or advancements which are going to harm, or which are going to accrue harm on the people. So, generally the market has failed to give any indication of being a viable assessment agency, but yet it can play a significant role. The public persist in demanding consumer goods with little concerns of inherent dangers or long range hazards. More, the public seem unwilling to pay higher consumer prices to abate the hazards. So, market control again is something which will be done through the law or by the instrument of the law. Market has its own market related laws, be it advertisement, be it competition, be it the approvals of marketing few things in the market, or be trademark. So, any such market regulation, or any of these market regulations may play a very active role in regulating the science or in regulating the developments of the science and technology. Well, at times market fails to assess, and this failure of the assessment is attributable partially to the consumer's failure to recognize potential hazards and consequences, and partially to an unconscious awareness that the social costs fall upon the general public and therefore do not directly affect the specific group. Courts have traditionally served as the primary instrumentality for internalizing the social costs resulting from socially responsible acts. Though the application of common law tort doctrines, the judiciary redistributes the social cost by placing financial liability upon those responsible for the injury. Thus, it operates directly upon the incidence of cost. So, viewers, you see, we see that courts are acting as a primary instruments in taking care of the challenges or hazards, right? Specifically, common law tort doctrines, judiciary by propounding new laws or by making law is taking care of all such developments or feats. especially it confers, or you may say it imposes a cost or if the damages are occurring to the creators of the technology. And in the legislative arena, there evolves a merger of law and politics. This interaction between demonstrative public concern and judicial doctrines results in statutes and administrative regulations which balance this societal benefits and societal risks of the technology, because politics and law both merge while making the law. Though they must be separate and they are separate pillars, but what happens in reality or in practicality is different, and we see that sometimes social benefits and social risks are of the technological feats or of the technological developments are controlled in a politico legal manner, right, in a politico legal manner where prejudices are bound or tend to occur, or may occur. So, notwithstanding the legislature's unique capability to implement legal process to protect the health, morals, safety and general welfare of the public, it too fails an assessment institution. At times the legislature also fails as an assessment institution like a market. In most cases legislatures like courts act after the fact. So, we all know that these ex ante laws they act after the fact, which means they are reactionary in nature broadly, they are reactive. Seldom does a preliminary assessment of technology motivate the legislature to enact legislation. And here lies the main problem, that before even the technology comes to the public domain, there should be some preliminary assessment conducted for making some or enacting some legislations, but it never happens. It is only after an obvious social problem arises and issue becomes politicized that legislative action is taken. So, this this ex post law or ex post laws are made which are generally politicized, and they do not cater to the they do not cater in a retrospective manner, they rather cater in a prospective manner. So, there is often a lag between identification of a social problem and its legislative solution. In order for the public to become concerned enough about the problem to generate the political and the legal response. If the market, the courts and the legislatures are unable to adequately fulfill this task of technology assessment, how can it be done? It can be done if the lawyers if the lawmakers, the legislature involves the scientific community and give them the adequate space to let their opinion be heard, then probably this kind of a problem or a lag shall get diluted. On the contrary, the other side, the scientific community must also involve the lawmakers or especially the public spirited people or some legal practitioners while thinking of creating new technologies, or especially while designing the new technologies, so that they inherently do not possess any problematic or any potential hazards they do not cause, or any problematic features they do not possess when they come into the existence. So, that is how it may be done. There is a need for new institutions which will involve both, and at this point one must distinguish science from technology, for it is his distinction wherein a part of the root of the problem lies. Technology is applied science. Therefore, the gestation period between the evolution of scientific discovery and development into a marketable technology is a potential period of intellectual introspection, during which research, debate and speculation about the potential problems of applying the fruits of discovery can develop. Time lags between scientific discovery and technological application continue to get shorter these days. Nowadays, the gestation period of the new technologies has decreased, and technologies are being made overnight or are coming into the existence overnight, but that period of gestation must be used by the lawmakers to introspect, to debate and to speculate about the potential hazards and brainstorm and then finally make a law. Ways are constantly being sought to reduce the technological lags because of the obvious economic implications. This period of lead time is precious for the in-depth assessment, yet it will continue to be shortened to its minimum practical limit by the technologist. So, we definitely need new institutions to address the constant tussle or the tensions which are emerging. Actually inherently there are no tensions, but because of certain lags or certain laxities, wherein the institutions are not involving people, or there is no inclusiveness, interdisciplinary inclusiveness amongst the people of both fields, which is why the laws are either which is why both the laws as well as the technologies are going wrong, right, or are causing bad effects on the society. So there should be no ad hoc assessment, rather there shall be a complete assessment, and then that lag has to be reduced, and number of alternative institutions have been proposed to serve this necessary function. There is a diversity of opinion as to specific role such an institution should play, the mechanics of implementation and to whom it should answer. It is generally agreed that the assessment institution must have a significant research component at its disposal, and to be effective the assessment institution must be staffed heavily by natural scientists and engineers with a significant complement of social scientists to consider the economic, behavior and political ramifications. So, bringing social scientists and natural scientists and engineers together is the answer to all the tensions which are occurring because of their merger or because of the bordering of their merger. So, because social scientists are well equipped to have the assessment of economic, behavioral, political ramifications. On the other hand, scientists or natural scientists are well equipped to understand the potential hazards which a technology may cause. So, new institutions involving or bringing both or these two institutions together may probably serve the purpose. So, whatever form the institution takes, it must be innovative in its approach to assessment and broadly multidisciplinary and unique, so that science technology institutions may prosper with the involvement of the social scientists or social engineers. Well, so far as the legal process in technology is concerned or its assessment is concerned, I already told you that law is normative, law is not based on any doctrinal structures or no doctrinal questions are available. Lawyer's role in a society or in a legal process is very important, and at times he or she takes the help of the technologies, and lot of technologies these days are being used by the lawyers. So, to conclude, I will say that law basically deals with normative principles and moral issues which are quite outside of science. The business of law cannot be consensual in the same respect as science. Science cannot tell us what ought to be done, it can only chart the consequences of what might be done. A recognition of these distinctive and complementary roles of law and science reinforces the argument for developing a close alliance between the disciplines. Scientists have also come to realize the importance of legal processes in achieving harmony between science, technology and society. With this, I just would like to recapitulate quickly as to how both the fields should work or have worked in the society. So far as these two sciences or two different disciplines are concerned, we have seen that they have a very large scope of intersection or their interface, and they are intersecting and intertwining with each other on multiple occasions in a multifarious ways, and lot of at many occasions it is very difficult to answer the complexities which one poses, and the answer basically lies in their being run in tandem. If both will run in tandem, then we may probably have the prosperity, and we may probably have the better results coming out of the both fields. As I concluded, that new institutions must come into the existence, which will involve social scientists as well as the natural scientists, and both should strive to address the societal problems, and that can happen only when we recognize that they play a complementary role in the society, and one reinforces the other or its sweep, and it must also be realized by the social scientist as well as the natural scientist that legal processes are also equally important, and on the other hand natural scientists should also understand that the social scientists should also understand that the scientific principles are equally important. So, with this my viewers, I would like to conclude, and I am looking forward to meet you with interesting lectures in this series called Law, Science and Technology. These are preliminary lectures on the law, science and technology. In this series, if you carefully see, there are very interesting topics which I am going to cover, ranging from the law on AI, ranging from the law on drones, or robotics, as well as nanotech and biotech, and so on and so forth. There are many interesting and new areas which are rarely taught or discussed in such great detail in the law schools in the country, or for that matter in the science institutions of the country. So, I urge you to watch this series completely to have a better understanding and to delve deeper into the intricacies of law, science and technology. Thank you very much viewers for patient listening. Have a good day.